Major breaking news. The United States Court of Appeals for the Second Circuit out of New York City has unsurprisingly found that Connecticut's AR15 semi-automatic rifle ban and magazine capacity bans are constitutional under the Second Amendment. But what is entirely embarrassing is just how terribly reasoned and sloppily analyzed the Second Circuit, supposedly an important smart court, how they totally screwed this case up. Let's talk about how the Second Circuit embarrassed itself, beclowned itself in this case of National Association for Gun Rights versus Connecticut when we come right back. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so we have a 3-judge panel here out of New York City that just issued a ruling saying that the federal district court, the lower trial court, in the case of National Association for Gun Rights and the Second Amendment Foundation, among others, against the state of Connecticut, how it was appropriate that the district court judge upheld the law and rejected a request or a motion for a preliminary injunction. The Second Circuit said, indeed, that Connecticut's law banning AR-15s, the semi-automatic rifles, and magazines that hold more than 10 rounds, that this is entirely consistent with the Second Amendment. To summarize the reality of this opinion, in my view, is that the Second Circuit beclowned itself yet again when it comes to our Second Amendment rights. And it's not even close, folks. Not even close. A total embarrassment of jurisprudence out of the financial capital of the world, which is not a shock because probably none of the judges have ever touched a gun on the Second Circuit. So I'm just going to hit a couple of the highlights or lowlights as to just how embarrassingly they screw this up. To begin with, the entire premise of this Second Circuit decision that upheld Connecticut's so-called assault weapon ban and large capacity magazine ban, the entire premise of this was that there is this newfound phenomenon, this unprecedented societal concern in the form of mass shootings. Now, this is terribly reasoned. And I'll tell you why you know it's terribly reasoned. Is because the Second Circuit relied entirely on hear what I just said? Part of a sentence in the U.S. Supreme Court's decision in Bruen. Because in Bruen, they talk about how you're supposed to find historical analog laws, and then you apply to a modern-day gun control law to see whether or not the Founding Fathers basically accepted this law as consistent with founding-era principles of law when it comes to the historical tradition of firearms regulation. That's fine. But what they did here in the Second Circuit is they spent almost half, I would say, of their something like 75-page opinion talking about how guns in the context of mass shootings, these rifles are bad. So to begin with, as you know from basic Second Amendment jurisprudence, the focus of defining the scope of the right to keep and bear arms is not on how the guns are misused by criminals. You see, we don't narrow the scope of constitutional rights by virtue of how some psychopathic wackadoodle nut job misuses firearms, or for that matter, misuses language, misuses his right to free speech, misuses religion in the name of some murder somewhere. We don't narrow the scope of constitutional rights because some wackadoodle somewhere could misuse religion, can misuse free speech, can misuse a church, can misuse guns. We measure and evaluate the right to keep and bear arms and other rights by virtue of how ordinary law-abiding Americans actually exercise those rights. And yet this entire decision is all about how a handful of wackadoodle nut jobs misuse firearms. That perspective is entirely wrong. But the Second Circuit obviously doesn't get it because they don't want to get it. They're not dumb. They're feigning ignorance, in my view. They're pretending to do the analysis when all they're doing is they're just basically phoning it in and getting to the outcome they want, which is to make sure that people cannot have the right to keep and bear arms. It's not going to work, folks. The Supreme Court is going to spank them in the next 18 months. Not necessarily in this case, but in one of the cases coming up. But I digress. So aside from looking at the wrong perspective, which the Second Circuit did, the other, and this is to me the utter embarrassment, borderline law malpractice in my view. Tell me if you disagree. There is a sentence in the Bruen case, which I actually wrote about extensively because I pointed out how the anti-gunners were going to misuse this, and it was clearly going to be wrong. There's a sentence in Bruen that reads the following. Let's look at this carefully. While the historical analogies here and in Heller are relatively simple to draw, other cases, hear what I just said, folks? Other cases implicating unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. Did you see that sentence I just read to you, folks? Did you know that that sentence does not appear in its entirety in the Second Circuit decision? But part of it does. Specifically, the parts talking about unprecedented societal concerns on the grounds that mass shootings with these types of guns are somehow unprecedented societal concerns. And therefore, they're allowed to engage in a quote-unquote more nuanced approach. Well, here's the problem. Let's look at the entire sentence again. The entire sentence that the Second Circuit, in writing their 75-page opinion, apparently could not find the space or the words to use the entire sentence. They cherry-picked just a couple words out of the sentence. I wonder why. Let's look at the sentence again and analyze it, and just to see how embarrassing the Second Circuit got it. Let's look at the first clause of the sentence. The Supreme Court in Bruen writes, quote, while the historical analogies here, which is the Bruen case, and in Heller, see that language? Are relatively simple to draw. Other cases, meaning other cases other than Heller and other than Bruen that implicate unprecedented societal concerns or dramatic technological changes might require a more nuanced approach. You see what just happened there, folks? The reason why the Second Circuit did not put that entire sentence in there is because it literally wipes out their entire opinion. That's my view. I'll tell you why. The opening clause to that sentence in the Supreme Court's decision in Bruen literally says that the historical analogies by the U.S. Supreme Court have already been identified and analyzed and applied in the Heller case. What was the Heller case about? Heller identified the legal standard, the principle to apply when a lower court is interpreting the Second Amendment and applying the Second Amendment to an arms ban case or to any case dealing with whether or not a particular type of arm is protected under the Second Amendment. The Supreme Court already did the work. They already found the historical analogies. They already analyzed it in Heller and came up with the in common use test, which derives from the historical principle that you can ban or restrict firearms or arms that are dangerous and unusual. Literally written into the opinion in Heller and then reiterated in Bruen. And then, of course, that sentence that sentence goes on to say that other cases, meaning other cases other than Heller, the arms ban case, other cases other than Heller defines what is a protected arms. So rather than apply Supreme Court precedent, these three judges, these moronic judges on the Second Circuit, and that's how they behaved in this opinion. That's just the reality of it. I don't care what their credentials are. I got fancy credentials too, probably better than theirs. I don't care. This decision was moronic. Judicial activism at its height, in my view. And the fact that they did not quote that sentence is a reason why. Because they didn't want to talk about the first part of the sentence. They didn't want to try to explain away how they can decide that AR-15s and semi-automatic rifles and the magazines that go with them are not protected arms under the in common use test, which is derivative from the dangerous and unusual, right? Because if something is in common use by Americans, we the people, it cannot by definition be dangerous and unusual. Because in common use, it can't be unusual. If it can't be unusual, it can't be dangerous and unusual. But they didn't cite the whole sentence. They didn't quote the whole sentence because they knew if they did, it was going to blow up their entire opinion. They only cherry-picked a few words out of it, conveniently ignoring the fact that the Supreme Court has already set the precedent that is binding on these lower inferior courts to apply. And the Second Circuit refused to do so. Obviously, in my view, judicial malpractice by these three judges. But let's go on. We also know that when you're dealing with mass shootings, which they say is unprecedented societal change, well, that's not true. I'll tell you why it's not true. It's very obvious. When the Supreme Court discussed unprecedented societal concerns, they pointed out that Heller had already been decided, right? While the historical analogies are here in Bruen and in Heller relatively easy to draw, other cases implicating unprecedented societal concerns. They're talking about unprecedented societal concerns. So the question is a mass shooting with guns an unprecedented societal concern in the year of our Lord 2025? The answer is undeniably no. As a matter of American law, not just historical fact, American law. Why do I say that? What year was Heller decided by the United States Supreme Court, folks? The District of Columbia versus Heller case was written by Justice Scalia in the Supreme Court in the year of our Lord 2008. 2008! And they came up with the in common use test derived from the historical principle of you can ban dangerous and unusual weapons. That was in 2008. And why is that important, folks, for defining what is an unprecedented societal concern? It's because in the year of our Lord 2007, a year before the Heller decision was decided, what happened? In 2007, you had the Virginia Tech shooting where some nut job wackadoodle guy took semi-automatic handguns and magazines that held more than 10 rounds and killed dozens of people at Virginia Tech in 2007. And then in 2008, the Supreme Court decided the Heller case, setting forth the dangerous and unusual historical principle, and therefore, if it's in common use by definition, it cannot be banned because it's not dangerous and unusual. It occurred in 2008 after the Virginia Tech shooting. It also occurred, of course, after the University of Texas shooting back in the 60s and the Columbine shooting back in like 1994, whenever that was. The point is, when the Supreme Court decided Heller and focused on the lawful uses of guns and what we the people buy, we the people want and choose for self-defense, the notion of guns being used for mass shootings by wackadoodle nut jobs, it was not unprecedented. So if an item, if an object, if an event was not unprecedented in 2008, how on earth can it be unprecedented in 2005 and being used as an excuse to skip over the meaning of the Second Amendment? It cannot be. Now, this is basic logic that virtually everyone who watches the Four Boxes Diner channel understands. But do these three morons on the bench in New York City that have beclowned themselves with this opinion, do they understand this? Apparently not. Or if they do understand it, they want to feign ignorance and play dumb. Now, whether or not it's an act or reality, I'll let you be the judge. You see, in addition to the main opinion by the three judges, there's a concurrence there by Judge Allison Nathan, a Joe Biden appointee. Now, Judge Allison Nathan thought she was being clever with her concurrence. But the truth is, I was embarrassed for her because the points she made were sophomoric. They're the sort of thing that I would pat a high school freshman on the back for noticing the difference. But for a federal judge that should be familiar with Second Amendment jurisprudence and the history of American law versus English law, again, another example of a Second Circuit judge beclowning themselves to make sure they get to the right outcome from their perspective that throws our right to keep and bear arms under the bus. Specifically, she says in her concurrence that the Supreme Court has informed the lower courts that they must engage in historical analysis, which is what she's going to do. And then she points out something that everyone has always understood, that William Blackstone's commentaries, which set forth English law, by the way, English law, when he talks about dangerous and unusual weapons, in English law, he makes a reference to dangerous or unusual weapons. But the Supreme Court, you see, when interpreting the Second Amendment, says that the historical principle that they have derived from looking at the history in the Heller case, again, the Heller case deals with an arms ban. This case, the National Association for Gun Rights case, deals with an arms ban. The Supreme Court has already done the work in figuring out the legal standard. All the Second Circuit had to do was apply it. But instead, they want to go back and reinvent the wheel because they think this is a moot court for college kids and not doing their job, which is to follow Supreme Court precedent, which is why Judge Nathan in our concurrence is like, well, William Blackstone in his commentaries, the English lawyer wrote dangerous or unusual. And yes, the Supreme Court has said that there's a historical principle in the United States that you can ban or restrict dangerous and unusual arms. But if you look at Blackstone, he says dangerous or, and therefore I just have to, a gun can be either dangerous, unduly dangerous, or unreasonably dangerous, or can be uncommon. But of course, the Supreme Court has already addressed this idea of the relationship between English law and American law when it comes to firearms. And we all understand, if you know anything about Second Amendment jurisprudence, that the United States and America's founding fathers viewed the right to keep arms more broadly than the English did, for several obvious examples. Number one, the English Declaration of Rights from the late 17th century says that the right to keep and bear arms only applied to Protestants and not to Catholics, but the American Second Amendment applies to all Americans regardless of religion. That's one example where our interpretation of the gun rights was broader than the English. Number two, also keep in mind that the English Declaration of Rights only restricts the ability of the king to regulate guns and arms. It didn't restrict Parliament's authority to regulate guns. We in America prevent the Congress and all the legislatures from being able to regulate guns in an unconstitutional way. Again, in the Second Amendment, we have broader protections for the Second Amendment rights than the English did. Third, the Game Act in England, which was abused by the kings to try to take away gun rights, use that as an excuse to disarm the peasants, if you will. In England, every deer, every rabbit, every animal belongs to the king. But in the United States, it works in reverse. As a general matter, the animals on your property generally belong to you, with some exceptions. But the presumption is not that everything belongs to the government in America like it was in England. Again, another example of the American vision of the Second Amendment, the American vision of the right to keep arms is broader than the English one. So it would make sense that even if you want to assume that the English lawyer, William Blackstone, uses the phrase dangerous or unusual, we in the United States have a broader conception of the right, and therefore dangerous and unusual. The conjunction before you can regulate or ban guns makes a lot of sense. So to wrap up, this opinion is not going to be the law of the land. This opinion is not going to go to the Supreme Court because it's on a preliminary injunction basis. It's interlocutory. The bottom line is this, folks. This is another terrible decision and further proof that the U.S. Supreme Court needs to step up, take one of these Second Amendment cases dealing with assault weapon bans, AR-15 bans, and spank these lower courts to make them do it right, because they're simply thumbing their nose at the Supreme Court and Supreme Court precedent. And I think the Supreme Court is going to be made aware of this if they don't already know this, and it's going to get fixed. It's going to get fixed in the next 18 months is my guess. But again, the history of the future has yet to be written. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at 4boxdiner. Don't forget to subscribe to YouTube and to Rumble, and I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.